Let's talk about misrepresentation in the common law's contract law. Can I shorten that word in the way that English speaking lawyers do? Misrepresentation is a little bit much, so we call it misrep. Why is it important? Well, if you're a commercial lawyer and you're dealing with big clients and you're drawing up contracts for them, you need to know about misrep. And I think the best way to explain how important it is to tell you that this year, if you look at the 10 biggest contract disputes in London, 7 of them, were breach of contract, much as you would expect, but 3 of them came to court or arbitration on the grounds of misrep. So let's explain what it is. And I think the best way to explain is if I tell you a true story of what happened to my company. I got very caught up in a misrep case, and I think a real story is always easier to understand than a legal definition. So come back in time with me to about 2012. I dread to think how young most of you were then, but that's about when this happened. In those days, where do I begin? Google. Coming up, number one on a Google search was everything for marketing. It's so hard to think of now with all the social media that we have and AI providing information. But believe me, in 2012, Google was king. And we were running a legal English business from a beautiful website. Our problem was, as more and more businesses became active, we were slowly slipping down the Google rankings, meaning that you, our students, and people who wanted to learn legal English weren't finding us. And at that time, people didn't have the tech knowledge or the software that they do now. So what you had to do was use an SEO help company to get you back up the rankings. SEO, search engine optimization. In other words, a company like us would pay money to these tech experts and they would push us back up the Google rankings. So that's how the story begins. What happened next was that I received, as the director of our company, the standard form contract of this SEO company. A standard form contract means we were presented with terms and conditions and they're non-negotiable. A bit like when you hire a car or you get a phone contract. It's always a standard form contract. You can't get into a discussion with them about parts that you don't like. So I knew it was a take it or leave it deal. And it was a good contract. Obviously, I read it, I liked it a lot, but I hesitated because the minimum term, meaning duration, was 12 months and it was £1,000 a month that we would be contracted to pay. And of course, in return for that, they could not guarantee that we would go back up the Google rankings. British contracts don't really use that word guarantee. And the word warrant, if you've seen it, it doesn't mean guarantee. Our lawyers try to stop us from guaranteeing things. It's too easy to break that promise. So 12 months, £1,000 a month with no guarantee. I was thinking about it when my phone rang. Now, these days, that would be considered an assault almost, just to ring someone's phone without telling them that you're going to do it. But in 2012, it was still okay. It was still quite normal. And it was a woman called Anna from the SEO company ringing to persuade me to sign. And I said, well, okay, I don't think I'm going to sign today, but I've got a few questions. Fire away, she said, fire away. Now, fire away means go. I'm ready for your questions. And I said, my main concern is not the lack of a guarantee. I can see in the contract that you are going to add content to my website and you're going to write blogs and articles about my business. And I don't know who's writing that stuff. And because we sell English lessons to lawyers, it has to be perfect. And she said, right, don't worry. All of our writers are graduates. They're extremely literate. We use Grammarly anyway to check that everything's okay, but we will run everything by you first for you to say yes or no before we publish. And I said, well, okay, that makes me feel better. Let me think about it. And she said, well, you do need SEO. I'm looking at your ranking on Google now, all the pressure. So I thought about it for 2 or 3 days and then I signed the contract. So now I am bound. It's a binding contract and I'm tied into it for 12 months at £1,000 a month. Part 3 of the story is the really tragic part, the part that almost gave me a heart attack, if I'm honest. I was teaching in Cambridge. I had a class of lawyers and I saw my phone light up on my desk and I thought, oh, I'll read that at coffee time. And it was Melissa in our office in a panic to say, this SEO company have written a blog and they've added to the website. I can hardly speak because I'm still so horrified all these years later. Full of grammar mistakes, badly written, information that was not accurate. And of course, we're advertising to lawyers. And the worst thing of all, a blog that appeared on a site right next to a blog about Viagra. If you don't know what Viagra is, Google, but you do not want your legal English business next to that blog. So I called them at lunchtime and I said, take everything down. How dare you? This was not run past me. This is a breach of contract. And then I realised that it was not actually a breach of contract. Have a think about why. All of those things were promised to me over the phone and not one of them was in the final written contract that I signed. The final written contract did not say everything would be written by a graduate. It did not say it would all be run by me. I had nothing in that contract that could stop my obligation to pay. But I stopped paying because obviously I'm not going to pay for another 11 months for them to harm my company. So I emailed them and said, I'm terminating this agreement. Your behaviour is disgraceful, blah, blah, blah. 2 days later, an email from their lawyer saying I'm in breach because I've told them I'm not going to pay for the next 11 months. And under our protocol, you have to send a letter before action before you can start legal action. You've got, and I guess your system's the same, you've got to give a final opportunity to pay. So I got the letter before action and it said if I didn't continue and pay the next month's £1,000, I'd be sued. They'd take me to court. Here's where misrepresentation comes in. I knew, or I was pretty sure they couldn't win in court because they persuaded me to enter into a contract with a misrepresentation, a misrep. So can you imagine what the misrep is? The misrep is everything that was said to me on that phone call that persuaded me to sign and then turned out not to be true. So I emailed them back and I said, I'll see you in court if that's what you want to do. But there was a misrepresentation here that I relied upon, and I would say to the judge, I would not have signed this contract without that misrepresentation in the phone call of graduates checking and running it by me and putting it through Grammarly. None of that was true, but I relied on it. Now, the interesting thing is, actually, I never heard from them again. So I can't tell you what a judge would say. But the remedy I would have asked for in court was to rescind the contract. Now, where you can persuade a judge that there's been a misrep, you can ask the court to rescind the contract. That means the court puts everyone back in the position they were in before the contract began. And what would that mean for me? That would mean them getting back their blogs and their content, and me getting back my first £1,000 that I'd already paid. So a remedy in the common law for a misrep is to rescind the contract. Now I can hear you thinking, how do you prove to the court what was said in a phone call? And the answer, of course, is you can't. No one witnessed it. But the judge will look at balance of probability. This isn't a murder. It isn't a bank robbery. It's not a serious crime. So the standard of proof is slightly lower. It's balance of probability. And if the judge thinks on probability that that phone call happened, I will win. Now, another day, I will tell you about the 3 different kinds of misrep. They are fraudulent, negligent, and innocent. And I don't think that woman's misrep was innocent. I think it was one of the other 2. Anyway, if you're a commercial lawyer and you deal with contracts, it's very hard to protect your client from misrep because it's the client that makes the misrepresentation, not the lawyer. Misrep.